Hey guys, Troy Dooley, the Beachside CEO. I hope you guys are coming off of a great weekend. I know that this is just one heck of a month. I think you guys have been watching. I just got back from Catalyst, and we go into that 90-day crunch where we're handling clients. We're focused on what 2016 is going to bring, and we're really just moving together to say, okay, how can we make this profession and our own businesses better? But this year it's been crazy. I've got a daughter-in-law that's in the hospital getting ready to have a grandbaby today. Tomorrow we marry off our 21-year-old. I go to Dallas for a company launch. I tell you, it's just great. And I feel blessed. And a lot of it has to do with the people that follow us, the support, the clients, the strategic partners we have, and it's you guys. And that's what I love. I had somebody reach out and say, Troy, you're doing all this stuff, and you don't look like those guys over at Seeking Alpha in their suits, and you don't look like the regulators. How do you expect them to take you seriously? And great questions when you think about it, because we are a little bit different. I'm not here to impress. I'm here to impress upon you what it is that we all need to do in business, not just direct selling. Any home-based cottage industry, any small business, brick and mortar, we handle all those. Matter of fact, we're getting ready to launch a brand new website next year that focuses on every different niche that's out there when it comes to a small or home-based business, because we believe that's important, from franchising to single-level plans to the direct selling business model to just entrepreneur startups. It's important. So we're going to cover that. But I also want people to understand that we're not here to just come down on one side or the other. And I know sometimes that I do that because I'm an advocate, I'm a proponent of direct selling, but I'm also not blind to the fact that there's issues in this industry. And that together we've either got to self-police and clean it up, or we're going to continue to see issues with regulators at both a state and a federal level. And those are the concerns that I have. A lot of the men and women that I hang out with are influencers in this industry that see exactly what I see, and they're out there fighting this crusade every day. I talked to somebody over the weekend and said, when I came up in the industry and was really making my bones out there in the field, the people that I was focused on reading was Guy Kawasaki on the Macintosh way. He was the first evangelist, a sales pro. Tom Hopkins, Tony Robbins, Zig Ziglar, Todd Duncan, all these people. It was powerful on sales. What could we do to make the close? And nowadays it seems like it's all about recruiting, and the people that are out there that people are going to aren't the Tony Robbins. Although he was just at GoPro, I got to thank Eric Voorhees for that. But a lot of these people are just, it's recruit. It's never about sales techniques and sales tactics and how to close the sale. You do have guys like Kelly Bangert, and you've got guys like Eric Voorhees and Todd Falcone and Jackie Ulmer, and there's others that do focus on that, but it's a small crowd. And I think that's what we've got to get back to if we're going to make this industry great, because I've been preaching this for years and I still believe it. At the end of the day, the person with the most customers win. That might be in your team, but it's going to be a massive amount, because that's what builds iconic companies, is when everybody's using your product. People laugh all the time about Amway, but their products happen to be in restaurants, in hotels, in people's homes. If people ever research what Amway is today, they would realize that they've still got a great network marketing organization, but that their money is made in so many different channels. Same thing with Longevity. When you look at Longevity, they are a multifaceted marketing company with all kinds of products out there. Those are the companies that last. Those are the companies that grow. Look at Apple, look at Starbucks, look at Microsoft. The list goes on and on. And that's what we've got to look at, which brings me to this most current situation with Vemma and the FTC. Vemma filed an emergency motion on Friday to get their new compensation plan approved through the courts. Now, this is after weeks of working with the FTC to try to come to a conclusion, and they hit some impasses. So when this was sent to me and I got a hold of it and I saw it, I thought, okay, this is just the motion. I need to see the supporting documents. The motion in and of itself is 12 pages long. With the supporting documents, it's over 86 pages long. And it's through looking at everything that you end up with an analysis or an opinion that helps you to know which way you want to take in my case, journalism. And we believe in a wisdom-based journalism. We want to give you knowledge, information that you can take and apply to your current situation. In order to do that, I'm going to tell you right now, this video will probably be longer than it usually is. We've been trying to keep them down to about 15 minutes max. But I want to go back to the original order that was made public on 9/18, or I pulled it down on 9/18, I think 9/17. This is what the judge stated, because you got to have this in order for me to go with the motion. He says and we're going to put this up in the blog post, likelihood of success on the merits of the FTC complaint. Operating an illegal pyramid scheme. He says, first, the FTC claims the defendant violated the FTC Act. He goes on and says the defendant, Vemma, is a multi-level marketing company founded and run by BK Borrego that sells nutrition and energy drinks through a network of affiliates. While there's no purchase of payments or fee is required to become an affiliate under Vemma's policies and the affiliate agreement, in practice, Vemma strongly encourages any person wanting to become an affiliate to, one, purchase an affiliate pack currently costing $600. That was the old plan. And containing Vemma product, which contains Vemma products, videos, audios, all that good stuff. You guys know the drill. And number two, sign up for a $150 monthly auto delivery of 2 cases of product. Very typical in the direct selling industry. You don't make people do that, but you say, look, man, if you want to max out the comp plan, if you want to go for it, if you want to be one of the big dudes, if you want to be like me, if you want to duplicate, if you want other people to do what you're doing, this is what you've got to do. Okay, understand? That's what we do. Here's what the judge had to say. And I want y'all to listen, because with information that's been filed through the courts now, I'm strongly leaning to the fact that the FTC wasn't necessarily going after Vemma, but they're interested in something else. And just listen. It says right here, however, he goes, much of Vemma's contention that it is not a pyramid scheme is based on a proposal to reclassify many of its affiliates as currently shown on its records to customers, which would have the effect of decreasing the amount of sales to affiliates and increasing the amount of sales to customers. However, defendants' proposed reclassification of affiliates to customers, as urged by defendant's expert Dr. Carr, is not based in fact. The judge is absolutely correct there. But now he goes on to say something else, and I'm going to go back to this fact for a minute. Defendant has offered no evidence to support a finding that a Vemma participant who intended to be just a customer accidentally identified themselves or herself as an affiliate, or had any motivation to do so. In addition, as the FTC points out, the reclassification proposed by defendants would serve to misrepresent how many failed affiliates there likely are. Both of those, not just one, is based on supposition and not fact. Because the only way that the FTC can say, oh, well, those are failed affiliates, and the only way that BK could say, or in Vemma, hey, these people should be customers, based on what the FTC is saying, understand this, is they'd have to put a call center together that called each and every one of those people that Vemma wanted to reclassify as customers. So both of those sides, that is not based on any kind of fact. Because for you to come to the conclusion that these are failed affiliates, then you have to be able to prove logically that every one of them intended to be an affiliate and to build a business, not, which is common practice also, just have somebody say, hey, man, it's free. Let me just go ahead and mark that for you, too. Because so many times when something's free and it's not going to cost somebody something, they just go ahead and sign up for it. And we know that. So that's listen to where I'm going with this, because we're going to go to this emergency motion here in just a second. In evaluating whether the rewards paid to distributors come primarily from recruiting rather than the sale of product to the ultimate user, court looked beyond the company's policies and procedures and examined how the company operates its practice. He quotes Burn Lounge. In practice, distributors may themselves consume some inventory as ultimate users, and thus a program that permits internal consumption is not per se a pyramid scheme. However, evidence that distributors purchase and consume product for the purchase of qualifying recruitment incentive is evident as a pyramid scheme. In other words, as the FTC expert Dr. Bosley correctly stated in her report, an ultimate user under the second casket prong could be a pyramid. And they're saying that that's part of what Vemma is because people were front loading and all that. It says the evidence before the court leaves little doubt that the FTC will ultimately succeed on the merits in demonstrating that Vemma is operating a pyramid scheme based on the cost deal. Now, this is going to get really interesting here in a minute. Basically what he's saying here is that the culture that was created, and I work with clients on this all the time, the culture that you create, your compensation plan can be totally legal, but if your culture is marketing it wrong, it will flip you into a pyramid situation overnight like that, because the regulators and everybody else is going to say it's all about recruiting, dude. It's not about marketing the product, no matter how you want to try to do it. So I looked at that and I understood where they were coming. One of the factual findings the judge quotes is, hey, this is all about recruiting and not really about the sales, although he agrees in here there's substantial sales outside the comp plan. He said many representations have no results, not typical. Disclaimer. It had no disclaimer whatsoever. That's part of the problem, is that it's a mess and it's got to be fixed. It's got to be worked on and looked at. And that's where BK and the team started recreating the compensation plan to put something correct. So in looking through all of the order, and like I said, I'm going to put it up on the website. You guys can read it verbatim. I want to go to the back. That's just the but I want to go to the judge's actual order, not just all of the supporting documentation in the beginning, because this is where it's really going to be, I think, important. Preliminary injunction, and these are the definitions that I want y'all to hear, because this is important too. Clearly or conspicuously means that its required disclosure is difficult to miss. We've already started telling all of our clients, you need to have an income disclosure at the beginning of the process of joining, not afterwards. Let people know this is going to be a hard freaking business to do. Here's what his order says. A, these are the prohibited business activities based on what the judge said. And this goes in line with what I'm about to tell you on the compensation. A, they cannot engage in, participate in, or assist others in engaging in, participating in a marketing program that, 1, pays compensation for recruiting new members, 2, encourages or incentivizes members to purchase goods and services to maintain eligibility, bonuses, rewards, commissions, etc. Cannot induce others to encourage or incentivize members to purchase goods or services. Cannot pay any commissions related to the purchase of goods and services unless the majority of such compensation is derived from sales to or purchased by persons who are not members in the compensation plan. Means basically 51%. With specific reference to corporate defendants' existing marketing program, can't sell business packs, can't link or tie the affiliate's eligibility for bonuses or affiliates' accumulation of bonus qualified points to the purchasing of products. Got to get rid of the to and go. Cannot misrepresent and assisting others in misrepresenting directly or indirectly, expressly or by implication, any material fact, including but not limited to the consumers who participate in the program, will not likely receive any commissions. Was that the most important? I think that was the most important stuff. So you get the drift of where I'm going. Now, nowhere in the order, nowhere in the FTC's complaint that I have seen, nowhere in the transcripts in the beginning, does it talk about the actual compensation model structure. In other words, Vemma was a binary plan. But in this new filing, this emergency motion that was filed, there's some disturbing facts in here that cause me to think that this was maybe not necessarily just a Vemma issue. And here's what's written. This is in part of the supporting document on why the motion was filed. It says, and this is from the FTC to the attorneys, Dear Mr. Quigley, we received Vemma's proposed compensation plan transmitted to us after hours on September 30th, 2015, and have conducted a preliminary review. The FTC objects to the plan given the complexity of the plan and the fact, let me redo this. Given the complexity of the plan, comma, and the fact that the plan does not describe many terms and conditions that will affect the implementation, comma, the letter described the FTC's objections generally without limiting the FTC's ability to object. They're saying why they're objecting. Now, here's what it says. Despite representing to the court that it would work to develop a business model that emphasizes retail sales to ultimate users, Vemma has proposed a compensation plan that is in many respects unchanged from the plan that Judge Tucci determined was likely to be a pyramid scheme. Period. Here's the part that caught my attention. It is a binary compensation plan that provides no new incentives for sales to ultimate users. As such, it will likely incentivize continued enrollment of affiliates in an endless chain of recruitment at the expense of retail sales. This looks as if the FTC is questioning the legitimacy of a binary compensation plan. Now, nowhere that I have found in the history of any company shut down as a proposed or as an alleged pyramid scheme has it been mentioned, including Burn Lounge, that the binary compensation plan was the culprit. It's always been the marketing program, the marketing messaging behind the compensation structure. In the motion itself, even the attorneys say, this looks like they're questioning the binary compensation plan. And if they are, there's many network marketing companies that have a binary compensation plan. When I started looking at some of the most current online information, Truth in Advertising, who went after Vemma, has now started a campaign against Jeunesse, which has a binary compensation plan. So there's some issues here that concern me. Because if the FTC is saying, well, we believe that the binary compensation plan is the issue, that changes everything that they actually filed against Vemma, and that causes a major issue within the industry itself. And I'm hoping that the FTC will clarify that no, it's not the binary that we're looking at. It's the marketing, the way every compensation plan could be marketed wrong. But it's concerning when I read through that. Now I want to read a few things here that I do think is very important for any company owner. And that is how this is set up. The new compensation plan at Vemma does not pay compensation recruiting of new members. The revised compensation plan does not pay any awards for the recruitment of a new affiliate. The revised compensation plan does not allow for the sale of affiliate starter packs, something the judge asked to get rid of. It pays no reward for recruiting to the sale of any such pack, and pays no compensation for recruiting a new affiliate. Exactly what the judge asked for. Section IA2. Does not encourage or incentivizes members to purchase goods or services to maintain eligibility for bonuses, rewards, compensation, etc., rather than the resale of personal use of the monthly. The revised compensation plan complies with this prohibition against the encouragement of inventory loading by explicitly providing that you will not be able to qualify for commissions based on your own purchases. This is old school, is what it is. Therefore, under the plan, affiliates will have no incentive to purchase products other than personal consumption or resale, which makes sense. That's what the judge asked for. Section IA3 doesn't induce others to encourage or incentivize members to purchase goods or services to maintain eligibility, bonuses, etc. Again, the revised compensation plan explicitly provides that you will not be able to qualify for commissions based on your own purchases. They have even gone a step further. This is under IA4. This I thought was great. doesn't pay any compensation related to purchase or sale of goods and services unless the majority of such compensation is derived from sales of purchases to people who are not members in the compensation plan. Vemma's calling this the 51% rule. You will only be paid on the volume in your organization that is at least 51% customer volume. You will be paid on all volume that meets this requirement. In other words, if 49% of your volume is affiliate volume and 51% of your volume is customer volume, you'll receive commissions on 100%. But if it's the other way around and 51% is from affiliates and 49% is from customers, well, you're only going to make 49%. So I thought, man, this is perfect. This is what the judge is asking for. But the FTC doesn't agree. Says doesn't constitute, these are part of the order, doesn't constitute a pyramid scheme. The revised compensation plan does not constitute a pyramid scheme under the Koskett test, and it doesn't. I'm not going to keep you all much longer here. The critical question for the FTC is whether the revenues that primarily support the commissions paid to the participants are generated from the purchases of goods and services that are not simply incidental. All of this, when you look at the order, when you look at the transcript, when you look at everything, came down to the FTC saying, rightfully so, hey man, we just want to make sure that the products are actually being consumed by people, purchased by people who want the products, and not are just there to try to hopefully make some money, which I fully agree with that aspect. But yet now it seems like every step of the way they're doing everything not. Here it is. The FTC's objections should be overruled. Now this is a motion from Vemma. Even though the revised compensation plan complies in every respect with the requirements and prohibitions of the court order, the FTC has refused to withdraw its objection. Based on a telephonic conference between counsel of the corporate defendants and counsel for the FTC on October 15th, 2015, email from the FTC counsel and the corporate defendants understand the FTC has the following remaining objections. 1. The 51% rule does not adequately prevent income loading and should be interpreted to disallow any commissions unless the majority of sales come from consumers. What the FTC is saying is if you don't have 51% of your sales with consumers, then you don't get any money. Whereas BK is saying, and Vemma is saying, hey, if 51% is from affiliates and 49% are from customers, we're going to pay you the 49% because that's customer sales. That's a great, to me, it was a great compromise. I thought that was ingenious there. Field leaders might not like it, but if the company stays open and you can go get a lot of customers, it's a win. Number 2, the plan is still a binary. This is an objection by the FTC. Multi-level marketing plan under which affiliates must have a downline in order to receive rewards for the program. For the reasons discussed below, the corporate defendant respectfully disagrees. 51% rule. And the legal counsel said, we're surprised at the FTC's position, not only because it's inconsistent with the inventory loading principles set forth in Amway and every other decision since Amway, including the Ninth Circuit's most recent decision on burn lounge, but because it contradicts the very position that the FTC urged in the preliminary injunction, which, I quote, this was during the cross-examination of Dr. Emmer Carr, counsel for the FTC, when they asked, wouldn't you agree that the effective Amway-type rule to keep affiliates from inventory loading, meaning purchasing product for the purpose of qualifying for commissions, be to simply disallow personal product purchases as a basis for consumption, which is what the new that doesn't qualify. You got to go out and get some customers. And yet the FTC is saying they don't like the 51% rule. And that's crazy when you think about it. Even more troubling, according to legal motion, is that the FTC overzealous objection to the 51% rule is in the revised compensation plan is the position the FTC now appear to be taking, which is what I'm saying. It's I hope they clarify this. That any marketing plan that is a binary and MLM in nature is objectionable. The FTC's objection is not supported by the terms of the order of the law. As already shown, the revised compensation plan complies in every aspect. My concern, and it's why I'm bringing this up, is that I truly do believe this goes further than just Vemma. I believe that the FTC, maybe they're pushing Congress to act, because at the end of the day, Congress really does need to clarify some things. The DSA probably needs to clarify some things. Courts really need to get on the same page. But if the FTC has decided we're going to go after individual compensation plans, and we're going to decide which ones are right and which ones are wrong, even though the courts for years have already done that. There's certain compensation plans we know are just, they're not good, and that's bad. But nowhere has the binary been an issue. Now, in looking at some stuff that's been written, I'm going to put this up. This came from my friend Lynn Clements. And he wrote some stuff that I thought was good. He said, the prohibition against applying affiliate purchases towards income qualification makes the court's entire majority of compensation is derived from restriction and your 51% rule completely unnecessary. It is an entirely redundant restriction. Very smart there. But he goes on to this, and I thought this was good. Secondly, in the motion to approve your new comp plan, the FTC is quoted as saying the majority of downline sales volume must come from customers rather than affiliates. That is not what the order says. It clearly states the majority of compensation must come from customers, which is a completely different matrix. I thought that was a good catch, too. And finally, there is much legal precedent that binary plans have never, not once in 26 years of existence, been legally challenged, even when the company employing such a plan was. Early in its existence, the mid-90s, there was a lot of shaky quasi-MLM deals who adopted binary plans. So there was a guilt by association. However, after many of these deals were hit with FTC or AG lawsuits, it became clear that it wasn't the binary plan itself that was the problem. I said that. It was that these companies were, what the companies were doing with the binary plan, which goes to the marketing. So smarter people than I, like Lynn, has actually seen this also. And this is why it's important that you as a rep, you as a company owner, you as strategic partners, as people of influence in direct selling, pay attention to this case, because some of you guys are probably marketing your program wrong. Some of you guys have binaries, and if this is going to be a binary witch hunt, you may be looking at ways to change your compensation plan before you get hurt. If you're reps out there that are using your own marketing material and you're not putting the good income disclosure statements up, you're going to get hurt. If you're a company that hasn't already put together an income disclosure policy and a solid income disclosure statement, you can get hurt. This is a time for the industry to pay attention to what the frustrations are with the FTC, what they are saying. It's time to listen to what the judges says, and it's time that we clean up our act. And we make sure that everything is done correctly. There are plenty of great products in this industry. There's great people that can go out there and they're good at sales and they're good at recruiting and they can build some great marketing and distribution organizations. But beyond popular belief, direct selling, network marketing, MLM, relationship, whatever you want to call it, is not right for everybody. They may love your products. They may become a white knight and share with other people that those people need to get a hold of you. But that doesn't mean that they should be a distributor in your company. Keep that in mind. Live life like it's an epic adventure. Stay dangerous, stay strong, and if you're in a home-based business, act like it.